Government assistance. This is a very interesting case in my opinion. A company called Com Dev was a satellite development company. It did work for the CBC and the government, and as a result of developing these satellites, it had losses on the contract. So it received $28 million. It had a $4 million loss on the contract. It had cost overruns as a result, because it only got $25 million, let's say, in payments for these satellites. And it claimed SR&ED on the expenses, the $28 million. CLA tried to argue that the $25 million that the CBC paid them was a contract payment for the SR&ED, so they only really get the $4 million of cost overruns, not the whole $28 million. Com Dev successfully argued that no, that's not a payment for research. They're just another customer. They came to us with a requirement to say, if you can build us a satellite at this price that meets these things, we'll buy it from you, and if not, we're going to go to one of your competitors. Okay? And then they look at a number of issues. So, who bears the risk? Am I being paid hourly and I get to keep the money no matter what? That's a payment for research. But if it's a fixed price contract where if I don't meet the criteria, I bear all the risk and you just don't buy it, you're just another customer. That's not government assistance. So they successfully structured their contract here to make it so that the payments were just another contract, just a payment from another customer, as opposed to a contract payment or government assistance for SR&D. And a lot of my clients will structure, particularly they work with governments, or they'll split contracts. They'll split a contract into an SR&D component and a monitoring non-SR&D component. Get paid more for the non-SR&D one and do the SR&D part for free. So again, you have to know to legally structure affairs ahead of time to make this happen, as opposed to trying and dealing with that after the fact. So you want to be a little more proactive there. Okay, Cultures Laflamme was one back from the 1980s where we had an experimental farm. They had $128,000, I guess, a claim of expenses for mushrooms. They sold the experimental development for $130,000. CLA tried to argue that you have to take proceeds of disposition and wipe out the claim. Again, tax court judge says there's nothing in the act to say that. The client got all their money in. Okay? So again, this is common now. I see it all the time. Or if you sold it, it must not be SR&ED. If you sold it, there couldn't be any SR&D component. It's a very, very bad mindset that a small segment of SR&ED reviewers have, and you've got to squash that right at the start, I find, or you're going to get into all kinds of problems down the road. Unpaid amounts.